Well, I think we'll get started. We know we've got a few people coming in, and I want to say, first of all, welcome. Thanks for coming in on this beautiful day. It's really tempting to stay outside, so we appreciate your attendance and hope you will learn some things and maybe even stay to join us afterwards. So my name is Stephanie Adamany. I'm WARF's Deputy General Counsel. And I'm here with Josh Carson from our licensing department, and we're going to be talking to you together today about WARF's approach to getting technologies to the marketplace. So this talk is part of a three-session mini-series that we've intended to explore the landscape for university technology commercialization. And 2 weeks ago, our colleague Beth Warner talked to this group, or talked in here about how WARF works with university investigators to protect the intellectual property that they create. I would like to make you aware also of the next topic, which is called Managing Conflicts of Interest when Starting a Company, Consulting, and More. So Andrew Norman from University Legal Counsel at UW-Madison is going to lead the session. He's going to talk about some of the gnarly issues when conflicts arise and consulting agreements happen, and that should be a good topic. And then next up, on April 23rd, our WARF's new Chief Venture Officer is going to be speaking. It's going to be part of the WARF Entrepreneur On series, and you can sign up for alerts about all of these events by adding your name to the list outside, and you'll get emails then. So today's session is going to focus on an overview of what WARF and other tech transfer offices look for in commercial agreements with industry partners. And we're going to wrap up by 4:45 and maybe a little bit sooner so that we leave some time for questions. And also wanted to let you know we record these sessions, and in about a week they'll be up on www.warf.org. And so therefore, if you have a question, we ask that you wait for the people with the mics to come around so we can capture your question and have it on the video. At 5, we'll adjourn to the atrium this way. I was going to point that way, but there's another event, so we'll be out here after where there'll be an informal networking reception, and we'll stick around to continue the conversation. So thank you, and we'll get started with our presentation here. Josh, get started.
Great, thanks. So we decided to choose a metaphor of a road trip for this talk. You don't need to be able to see all the different sections here, but we'll go through these each step throughout the way, from invention disclosure through how we find commercial partners, how you interact with them here on campus, and then finally how we negotiate licenses and a lot of the legal and business terms that we include in those agreements. I'm actually going to walk this direction and stand on the ground so we can cut back and forth, and because I'm so tall, we'll probably still be about the same height.
I can't respond to it this time. So I wanted to just talk a little bit about technology transfer. What does it mean? Because we throw this term around a lot. And so broadly, I think of it as transferring information. So transferring information, sharing skills, knowledge, technology, and development out of institutions, trying to get them into the marketplace, trying to get products and concepts going out into society. So think of the Wisconsin idea. That's one of the things that I thought of as I was thinking through this definition, and it seemed appropriate here. It's also this strategic commercialization. So identifying research that has the potential commercial interest, and then developing a strategy to really maximize that utilization of that technology into society. And also interesting, Wisconsin was the first, we like to say that. WARF was the first designated technology transfer organization. And since then, most universities have them, and not just in the US, but throughout the world as well. So we think about who we are. We're a designated patent management organization for the University of Wisconsin, and we're a nonprofit, and University of Wisconsin is an academic institution. So the backdrop of this is we're balancing some things. We're not a company, you know, with commercial shareholders and those things. So we have other considerations that we balance as we try to embark on this endeavor. So we're trying to transfer knowledge and technological developments out, which is kind of that broad sharing. We're looking at commercial potential and feasibility. So lots of innovations happen on campus. Some of them might be really cool and they're a better way to do something, but it is not commercially practical or may not be feasible, but it's adding to the knowledge base. So that's just one aspect that we're looking at. We're working with the PI to understand what the academic aims and considerations are. What are they looking to drive? What are their interests? And how do they have partners already that they're working with? Profit. It's expensive to file a patent. It's time consuming for us. It's time consuming for the PI to talk to us. It's time consuming to do licenses. So we want to have a recoup on that investment because our resources are limited and we want to make the best use of those, so that is a consideration. And then what are we trying to advance? We're trying to advance things in society, improve the state of the art. And so depending on the technology, there are a lot of varied considerations. So it depends on the situation. There might be other things. I haven't listed them all here, but that just gives you a background, kind of a framework that we're working within.
So as a brief summary from where Beth left us off 2 weeks ago, she described the very beginning of this process, going through invention disclosures and things that we think about when a new invention is coming in, as well as recent Supreme Court cases that have changed the way we think about a lot of our IP. I did want to go through a few commercial considerations that we think about when we're first taking in an invention. And those, there's things that we like you to think about as researchers, and there's things that we think about on the WARF side. For you as a researcher, we'd love it if you can think about what are the applications for your inventions, what are the benefits, how are they different from other things, you know, what is this the first time that this has ever been done, is this an improvement to something that already exists? What's the market for your invention? Who are the companies that you think might be interested in using it, as well as how big is the market? Is this a niche market, or is it a giant multi-billion-dollar global market? We also like to think about both market and tech trends. Is the markets that your invention might go into, are they growing, are they shrinking? Are there other groups who are your competitors working on this? Are there other labs that might have similar things that we would have to navigate as well? And then on WARF side of things, we're thinking about whether to accept an invention. We think about, you know, what is the likelihood that someone's going to take a license to your technology? How long is it going to take us to do to get to that license? You know, what is our strategy? We'll talk about some of this later on, exclusive versus non-exclusive licenses. We think about what our plan is going to be for that invention, as well as Stephanie mentioned, what we think our revenue might be. And as we have lots of other programs to help, including our own accelerator group, as well as D2B on campus, whether there's any necessary additional development that might need to be done. So as we go along this journey, if we've accepted your invention for patenting and licensing, what's next? Well, the first thing we think about, this is very important, is we consider the sources of funding that were attached to that invention. And Stephanie's going to go over why that's so important.
So there are a variety of sources of funding on campus, federal funding being a very significant source. There's also private foundation funding, grants from a variety of sources, and commercial research. And so as we think through what do they have in common, and I just put up here strings, they all have strings. And so most of our grants have some strings that we need to consider, and we need to consider that up front because those may dictate our next steps. As I mentioned, one of the biggest funders is federal funding, and there are some particular strings with federal funding. And that string is called the Vaginal Act. So this is a piece of legislation that was passed in 1980. It's named after Birch Bayh and Bob Dole, who were instrumental in getting it through. And one thing to note is that prior to 1980, we didn't have the system that we have right now. So we would have to petition or ask the federal government whether we could take title. So you can imagine that all of the different funding agencies, every invention perhaps that comes up, if you don't have another arrangement, you're reaching out to say, can we take title and license it? We're interested. And for all of the institutions, this was a lot of bureaucracy and held up the process. So the federal government back in 1978, I saw a stat, they had 28,000 patents, but they had licensed 4%. It wasn't a real, it's not a core part of their mission, and so a lot of things just weren't going forward. And so the Bayh-Dole Act, I'm going to provide a few highlights here, but the Bayh-Dole Act said we can take title, we just have to let the government know. So we report an invention, happens, and then we let them know if we want to elect title to handle the invention. So I just let the cat out of the bag here. Yes, we can take title. But it also says once you own it, we can't assign it to a commercial partner. So there are limitations to that. That's why we do licenses and giving them some rights to do what they need to do to be able to commercialize, but we can't assign it, transfer ownership. And also the government retains the right to use the invention for government purposes. So what that means is we do what's called a confirmatory license, where we say, okay, the government, we recognize that the government has the rights to use this technology for government purposes. There's some more reporting about the development and how that technology is progressing. And there's a provision that says the royalties shall be shared with the inventors, and most tech transfer offices have a policy around that. And I will expand on this a little bit later when we talk through some actual license terms.
So, as we go through the pathway, WARF does a lot of things on your behalf to try to identify licensees that might want to use your invention. So we we go to conferences, we work on marketing campaigns, we've got a great PR group at WARF. And then we also work ahead of time to make sure that companies are qualified before we might involve you as a researcher in any agreement. So that's asking them if they're qualified. So some of the things that we look for in these commercial partners, there's two main categories. One is whether they have an interest in developing your invention. And you might think that this is obvious, that a company has found us and wants to take a license, that they automatically have an interest in developing an invention. But in fact, occasionally we get requests for people that want to take a license and put an invention on the shelf for competitive reasons and stop anyone else from using it. And that's not something that we're interested in doing because of the Vaginal Act, as well as our core principles as a tech transfer office. We want to make sure that inventions actually get out into the world. So that's a key point, is that they have an interest. And then we also want to make sure that companies have the ability to develop. And that can be both monetary ability, that they have the funds to actually do research and development around your invention, as well as the expertise to do that. So once we have found that commercial partner, we've determined that they're qualified, we could either go straight here down into the licensing expressway, or it's possible you might start out with a collaborative agreement. In this case, it'd be something called sponsored research. A company might want to work directly with your lab before they would work with us to take the license. And there's a few important considerations there when we're talking about sponsored research. Now these are agreements that WARF actually is not party to. They're directly between the university and your lab and the company, which does create a slightly added layer of complexity. But we work really closely with RSP on campus to make sure that we're all working together and we're at the same guidelines. And there's a couple key terms in those that come up. Stephanie's going to go into a little more detail on.
So I'll talk about future licensing terms first. when this collaboration happens between a company and campus, and there might be some work that has kind of caused that to happen that they're interested in, often they want to say, okay, if an innovation happens, we'd like to have a license or at least an option to license that technology that might be invented but has not been invented yet. So that's typically a part of a sponsored research contract, and we look to just make sure there are some timelines. So we don't want an option forever, because then we don't have, if they're not interested, we're kind of stuck in that contractual holding pattern. So we're looking to just give them enough time that they can determine whether they are interested in taking a license, and then closing it up at some time, which maybe the end could be an actual license with that company, or we're free to license elsewhere. Background IP is an interesting one that comes up from time to time, and they say, well, what if we need other technologies that the university might have invented to practice that technology which has not yet been invented? And we take a line against that and say, if there is particular technology that we can identify together, we'd be happy to work with you on that and talk about an option to that as well, because we are here, after all, to get these technologies out and license them. So if there's that opportunity, let's have that discussion. But we won't commit a broad option to a lot of background IP, tying that technology up and not knowing whether they're actually going to need it or be interested in it or develop it. And so those are just a couple points to know about. And then those future licensing terms, kind of harkening back to the strings. When we get an invention disclosure, that's part of why it's important for us to review funding, to know what those terms are and what obligations we might have going forward.
So, after all of that, if there's been a sponsored research agreement or not, you could come straight to a license negotiation. There are a lot of things in that license, but before I get to those, I want to talk about maybe the difference between the size of the company that might take a license to your invention. There's going to be established companies or startups, and this is the only time I'm going to talk specifically about startups here, because really when we negotiate a license, whether it's with an existing company or startup, we're worried about most of the same things. We have almost all of the same terms in there. But you as a researcher might want to think about your invention in relation to the type of company that it might be more suited to. So an invention that might be more suited to an established company is something that complements something that they already have, is an add-on, or is a further step in a process that company has been developing. It's also something that could take significant resources to develop. If you're going to have to build a plant that's going to cost hundreds of millions of dollars to get off the ground, an existing large company is much better suited to doing that than a startup. On the other hand, if you have a technology that's platform-based, it could have lots of things come out of it, or if it's something that's really going to disrupt an existing company's business model, it makes a lot more sense to get that started in a smaller organization first. The other thing that we talked about here is that if you have something that you're worried might get lost in a big company, a startup's wholly dedicated to one invention usually, and that will give a lot more resources to that. You're not going to have to fight for attention and resources the way you might in a big company. So the actual process of negotiating a license, which is going to be next after this slide. I'm going to start out talking about what is a license. A license is a contract between a patent holder, an IP owner, and a third party. So that third party wants rights in the invention. They either want to make the invention that's described in the patent, they want to use that invention that's described in the patent, or they want to sell compounds that are claimed in the patent, or because patents are a territorial right, they might want to import one of those into a specific country in which you have that right. So ultimately, a license is permission for those rights in exchange for some sort of consideration. Most often, that consideration is monetary, and it's in the form of royalties or upfront fees or milestone fees. But oftentimes, the consideration can be data or information about the market or a summary of their development efforts as well. So at the end of the day, a license is a promise not to sue someone for using your IP as long as they comply with the terms of that agreement. So the process that we would normally go through, we've talked about it a little bit going up to here in bits and pieces, but this gives a greater overview, is we have those initial talks with the company. This is where we ask them if they're qualified, and then we get a development plan from them. We want to know what their exact plan is for your invention. Then we go into some of those business terms that we talked about. We want to know when the timeline is for the development, what those fees are going to be, how much a royalty is appropriate. And then in the case of a startup, we might negotiate some sort of equity in that startup as part of that. Once we've finished up with the business terms, then we call in the lawyers. And they help us up with the legal language, going through all of the nitty-gritty of the agreement, actually putting it down into a contract that WARF will sign with the organization. There's a lot of different types of licenses. There's a wide variety of smorgasbord, if you will. You can have exclusive or non-exclusive licenses, and that again kind of gets back to the type of company and the invention that you have. There's some inventions that can be used broadly by many different companies, so it might make sense to do lots of non-exclusive licenses, which gives multiple companies the rights to use your invention. In the case of an invention that's going to take a lot of time and money to develop, whether it's in an existing company or startup, those companies are going to want exclusive access to that invention after spending all that time and money, so we can give them exclusive access to that. Some inventions that we accept actually might never make it into a product that's purchased by a consumer, but they could, in the case of a lot of molecular biology tools, they can be very heavily used in internal research in different companies. So it is possible for us to do licenses specifically for internal research. And then Stephanie talked about this a little bit before, but we also do options, which is essentially putting that technology on hold for a specific period of time in exchange for consideration to let a company work on an invention and see if they want to do a full license. And then an additional variation on an option is something that we do specifically for inventors here on campus that are thinking about doing a startup. We call that a standstill. It's very similar to an option, except that it's free, and it's for you to start working on your startup here on campus, and we'll hold off on marketing and trying to license your invention until you've had time to decide if you do in fact want to do a startup. So, anatomy of a license. This is the most exciting part of the talk from a license negotiator's perspective. I'm going to go through the different sections of the license, and then Stephanie's going to talk a little bit about terms that we think are important. In a license, we start with a lot of opening clauses. They usually begin with whereas. They sound like a lot of legal language, but they're very important. They set the stage for the license. They explain why you're doing the license, who the parties are, and that you've come to this agreement together in good faith. There's also a lot of definitions in a license. They can vary from agreement to agreement, so each agreement has its own list of definitions that apply to that specific license. Then you have the grant. That's the actual part we talked about earlier, where we give someone a license to use our IP, and we specifically say what the rights they have are. Then we go into some development language. This is where we think about timelines, how long it's going to take someone to develop. We actually do put in requirements around that. If companies don't reach those development milestones or timelines, we can terminate the license. And that's to keep them honest and make sure that people won't agree to a development timeline and then stop later on. The consideration aspect is where we talk about the royalties, any payments, perhaps equity that we might take in the case of a startup. And then into some more less obvious legal terms, ones that are nonetheless very important. Warranties, record keeping, we want to make sure our licensees keep good records, as well as how long that license is going to last. We also talk about enforcement, who's going to be allowed to sue someone in the case of infringement. And then finally, because we're working with a lot of confidential information, we have confidentiality provisions that allow both WARF and our commercial counterparts the ability to keep things secret. So there are a lot of terms that come out of this that are very important that Stephanie is going to go through.
License field, it's a definition and a license agreement, and WARF's license agreement template is actually up and available on its website if you wanted to take a read through of it. License field is a term. And when we give a license, some innovations or inventions can be used broadly across a variety of fields. And if a company is just interested in developing a certain field, a product in a certain field, we'll kind of carve up the fields that way so that we can have an appropriate licensee for each field. And they'll be developing the technology that they're set out to do. And then also licensed territory, likewise, maybe they are interested in just having their product be sold or using the product in the United States. So they don't need a really broad territory, they just need one country. Patents are issued on a country by country basis. So for patents, that's an important defined field. Development timelines and milestones, and Josh has mentioned that, and I mentioned it earlier, and I put asterisks here because it's a vital requirement. So we do need to report in on those, and we take that seriously. And also, we don't want technologies to stagnate if it's not working out. So those are important terms for us. Rights for nonprofits and government entities. So another vital term, the government license. But we do also, keeping in this concept of who are we and why are we here, we reserve rights for nonprofits and universities to practice the technologies for non-commercial purposes. So we want research to continue. We don't want our licenses to tamper the flow of research in these institutions. Limitations on rights to future IP. This is also kind of a policy type issue, going back to that concept of strings. If the IP hasn't been invented yet, it's hard to know what our rights will be with respect to the ability to license it. And also, we don't want to be tying up future IP because we don't know if that's the right partner. So those are, and then the preference for US manufacturing. This may be kind of an odd one to people, but around the time that VIDOL was passed, there was a real push for manufactured in the US. So for products sold in the United States, they have to be substantially manufactured in the US unless we petition the federal government to get an exception, because that's just not, well, for some reason. And that too, like I mentioned, is a VIDOL requirement.
So at the end of this process, if everything goes the way we would like it to, it doesn't always, but it often does, you end up with a product on the market, which then brings royalties and revenue back to you as individuals, as well as your lab, and then to campus. And that completes what we like to think of as the virtuous cycle, where the university over here on the right has billions of dollars of research that flow through and send disclosures up to WARF that turn into patents there in the center, and we have almost 2,000 patents that we manage. Those patents get licensed, and we have over 500 active licenses to industry. As you go there up and above and over to the left side, those licenses give us royalties on product sales, which end up coming back to the annual gift that we give to the university, as well as royalty shares to inventors. And over the last 90 years, we've given over $2.5 billion back to the university. So at the end, we like to think of this, there's many ways to structure an agreement. It's like a giant mixing table. There's an almost infinite variety of ways you can turn those dials to get the exact agreement that you want. But as Stephanie mentioned with VIDOL and other agreements, there's limits to how far those things can go. So I thought this was a nice metaphor for the whole agreement process. Now we have two metaphors in this one.
So yeah, it's the landscape. It's considering who we are and what are our goals as an organization, and taking into account our affiliation with the university, and then finding commercial partners where we can work to get a good partnership going forward and hopefully move technology out.
Great.
Must have talked fast. I hope there are a lot of questions.
on the previous slide, it said you had 1,900 issued patents, but only 500 were licensed. Is that correct? And if so, why the discrepancy?
Yeah, not every patent that we apply for and get issued gets licenses. We would love it if all of them did, but for a variety of reasons, not every patent gets licensed. It could be from the market's not ready for it yet. We're not able to find the exact right company, and then sometimes patents have follow-on patents that don't always get licensed. Yeah.
It's also a cycle. So for just one quick second, when you get an invention, it's really early stage, so there tends to be a lag between as it ramps up and maybe becomes licensed or optioned, and then a product happens. And depending on the technology area, it can be a longer lag, like first on pharmaceutical, or if it's a plant variety, it might be a shorter lag. So that also plays into the numbers.
I understand why you're focusing on the United States, but what about foreign patents? Sometimes things may be patentable in other countries. What's the policy?
Yeah, so we do patent in foreign jurisdictions a fair amount. It's really costly, as you can imagine. The more countries you file in, the more your costs go up. So we give a lot of consideration to who the likely commercial partners are, and where do they operate, and where are they likely to want that coverage. And a lot of times we look to see if we have a licensed patent and we still have time to file in those countries. We'll work with them to choose what countries, and then typically they're reimbursing. So it's a safer way to do it from a resource standpoint. So there's an element of a judgment call if it hasn't been licensed already, what countries it makes sense to go into and how to deal with that. It's kind of like we work together on teams debating whether or not it makes sense, and someone makes a case for it, and then we do it.
Fortunately, we do have a little bit of time because of the way, Beth would have talked about this a little bit 2 weeks ago, because of the way the patent system is set up. We have about a year to decide whether we want to file internationally. And so during that time, we can hopefully find a licensee, or if we don't right away, then we work in teams to decide if each individual technology makes sense to file internationally.
Is the year starting at filing or
The time of filing. Yeah, from it's called provisional. Correct. Yep. Yeah. So we don't have to have an issued U.S. patent before you file internationally. We can file a provisional patent in the U.S. that gives us a year to decide if we want to file internationally.
Within the EU, you file what's called a PCT, and that's sort of a holding place, and then you can decide your countries later. So that gives you a little bit, pushes the clock out a little bit, so you don't have to make the decisions right away.
Yeah, so there's sort of a continuing escalation of at what point in time we have to, there's a lot of decision points in the international patent.
Said you had 400 disclosures on average every year. How many patents will you apply for out of those 400 disclosures on average?
Yeah, we usually accept about half for patenting, and then as the previous gentleman mentioned, not all of those will issue as patents right away, or sometimes not even at all, but when we go through our monthly process, we usually accept about half for some sort of patent protection.
Okay, is that it for questions? It looks like it is. So I think we should be set up for our reception. Hold our breath and see whether we're
Get everyone out of here a little bit early to enjoy the sun
Yeah.
before it starts raining later this week.